well late.
Okay.
My Lord, yesterday the state signaled its intention to call the person from Trekker regarding the red polo that has been mentioned by the witnesses. However, yesterday the state efforts to secure the attendance of this witness drew a blank. But fortunately, today she is available, my Lord, and the state would like to lead her evidence first. I've informed my learned friends that we intend to lead her evidence. She's going to introduce a new exhibit. It's the Trekker report that we have marked Exhibit P. Just beg leave to hand up the new Exhibit P. Her name is Miss Maria Elizabeth Pretorius.
Has the defense had an opportunity of studying that report?
Yes, indeed. It was given to them, I think, on Monday, my Lord.
That's correct, Mr. Mgumezo.
That's correct, my Lord. My Lord, before the witness can be led by the state, I would like to request the basis for introducing this evidence before this court. And which kind of evidence is it supporting? Because in my true recollection, I don't remember any witness talking about the registration numbers of this vehicle. Moreover, my Lord, this motor vehicle is alleged to have been driven by Longwe Thwala. And why it is the prerogative of the state, of course, not to call him. But what are the intentions of the state to lead evidence that relates to Longwe Thwala? The state has clearly stated that they are not going to call Longwe Thwala. And this witness cannot prove, in terms of the location of the vehicle, we are not sure about the registration numbers of that motor vehicle.
Is that all?
Why Longwe Thwala is not called? The state does not want to advance genuine reasons as to why they are not calling Longwe Thwala, being the driver of that vehicle on that particular day. The basis for this objection is that in relation to the movement of this vehicle, it amounts to hearsay, and that the evidence that will be elicited by this lady, especially that it deals with the registration numbers of the vehicle, we are not sure whether that vehicle was the one that Longwe was driving on that particular day.
I don't know.
I'm addressing the court so that I'll put it on record.
Fine, yeah.
So that the state can respond from my submissions.
Okay. Mr. Ramsepedi?
As the court pleases, my Lord, in as much as the state is dominus litis, I cannot tell the state which evidence to lead. The state needs to be honest with the defense. Yesterday we were informed that this lady will not be coming anymore. And then we are resuming with Colonel Gininda. We want to hear from Colonel Gininda whether he wants to testify during his writing of the exams or whether we stand down until he finalizes exams, then we come back. Now today, to our surprise, this lady is here again. I can honestly tell the court I've never consulted accused number 2 regarding this document for that reason, my Lord. As the court pleases.
Mr. Mneshi?
That is the same position.
Same position.
When we were meticulously informed that they are unable to get hold by the state, we were informed by the state that they are unable to get hold of a person from the ABL recording company, and therefore we proceeding with Mr. Gininda's evidence. That's what we are expecting to be happening today. Thank you.
Have you heard of the adage that Jesus Christ arose from the death after 3 days?
I'm a Muslim.
Yeah, fine, but
yes.
The Christians and the Muslims know that. I'm saying the Muslims don't know that there's a gentleman called Jesus Christ.
No,
Never mind that.
Jesus Christ, I don't know him.
You don't know, okay?
My lord, I'm in the same position. I have
Yes.
not consulted with my client. I was under the impression that Brigadier Gininda is going to be coming. In fact, he gave us assurance yesterday that he was going to be here, so that we resume with his evidence.
Ms. Mshololo?
Same position, my lord.
Same position. Mr. Baloyi, what's your answer to the...
Well, maybe to start with the submission of Mr. Ramusepeli, that the state indicated yesterday that the state was no longer going to call the witness anymore. That is not correct, my lord. We said we couldn't trace the witness yesterday, and that as a fallback position, we're going to call Brigadier Gininda. But we managed to trace that witness, and that is the reason why we're calling the witness now. Now, as regards the submissions of my colleague, Mr. Mgomezulu, firstly, that there's no evidence regarding the registration number. Should that become necessary, my lord, we will lead evidence on that. But he has invited the state to address the court on why the state's intent placing this evidence before court. And for that reason, my lord, we've prepared brief heads of argument that we want to advance. We'll just give a court a copy. My lord, we foreshadow our heads by referring to
Please, the record, I do not intend to stop what the state intends to do. But this is a horrible ambush. The state is preparing heads of argument on what? Who has requested the state to prepare heads of argument? Because once the state is preparing heads of argument, we'll also be expected to submit our own heads of argument. We don't know what these heads of arguments are, whether they need our response or what. Procedure does not.
Yes, Mr.
That's not how the procedure is done.
My lord, Mr. Mgomezulu is inviting the state to address the court on the relevance of the evidence.
All right.
Now we're trying to do that, and now there's an objection. We submit that the defense cannot stop the state from advancing an argument. If they want more time to prepare the argument, they're at liberty to do so, my lord, but they can't stop the state from advancing its own argument.
Yes, Mr. Nisi, you say you can stop the state. That's what Mr. Valerie is saying. From advancing reasons why this witness is being called. Because Mr. Mgomezulu has elicited that information. And now the state says it is responding pursuant to that elicitation by Mr.
When was
Mgomezulu.
that raised, man? When was it raised?
No, but
that the state needs to explain the reasons why this witness being called.
No, but you're not listening. The state says Mr. Mgomezulu
Yes.
says he wants the reasons why this witness must be called. Is that not so, sir?
Indeed, my lord.
And then you say these heads are intended to address that exigence. Wait.
Okay.
Are they intended to address Mr. Mgomezulu's exigence?
Indeed, in fact, if I can just correct Advocate Nisi, as early as yesterday,
Yeah.
Mr. Mgomezulu signaled his intention to object to the evidence,
Yeah.
and it was on the basis that we prepared the heads.
So you want a ruling on that, sir? Can you stop the state from calling any witness?
That is exactly what I'm saying, my lord.
No,
We
but
cannot.
I'm asking, can the defense stop the state as the dominus litis from calling any witness?
I'm addressing that, my lord. I'm responding to that.
Okay.
That is trade law, my lord.
What is trade law?
it is strike law that the state can lead whatever evidence that they want
Right.
to lead, whether it is relevant, irrelevant,
Right.
necessary, unnecessary, whether evidence is there or not there. They can lead whatever that they want to lead, but there should be a basis for leading that evidence. It is very simple, madam. I mean, if
But Mr. Mnisi, Mr. Baloyi says this is the basis. Sir, are you not saying that?
Yes, indeed.
I'm listening. He says this is the basis, and you are saying there must be a basis. Here is the basis according to Mr. Baloyi.
I'm not saying there must be a basis, man. I only heard Mr. Gomez today on record saying that the state should indicate the reason why they would want to lead this evidence, because the testimony of this evidence will be a continuation of a hearsay about hearsay.
Fine.
I heard him now, but the state already has prepared heads of arguments.
Mr.
When
Baloyi,
are we
sorry.
supposed to respond
Mr.
to
Baloyi
this?
says he was duly advised, or it was intimated to him by Mr. Mngomezelo yesterday that he's going to object to the recording of this witness. That's why he has typed and prepared these hits.
Unfortunately, I wasn't privy to that communication. man. But maybe-
I heard that.
Maybe it's an issue.
Mr. Mngomezelo, I'm misquoting you. That you said we are going to object to that evidence. Did I hear you correctly yesterday?
My Lord, I've indicated that way.
Yes.
My Lord, there's one thing that puzzles me. It was just an informal discussion between myself and Mr. Baloyi. We were made to prepare. We even listened to Brigadier Kininda speaking. We're preparing for this. If Mr. Baloyi or Advocate Baloyi was intending to serve us with these heads of argument, he could have done that, even electronically. It doesn't do that.
So you want time to peruse the hits?
We still have to respond from what he was responding on.
So how long do you need for these hits? There are how many pages? 5 paragraphs, 6 paragraphs.
30 minutes is fine. 30 minutes is fine.
30 minutes. Ma'am, I'm sorry about this. Okay.
My Lord, if I can make a proposal that we go ahead, advance our argument, and if they need time to respond to that, my Lord, they can do so. And Mr. Mngomezelo himself, yesterday when we resumed, he put it on record. It was not a private discussion. He put it on record that he's going to object to the evidence of the person from Trekker. I'm surprised that he says it was a private discussion. It wasn't. It was on record.
Mr. Baloyi says maybe he should lead the witness, and thereafter we adjourn. And if you want to, as you say, you want 30 minutes. Is that okay?
My Lord, I thought he was saying he was going to advance his reasons
Yeah.
for this
But
witness
he
to be
says,
called. Not for this.
as he says he's advancing the reasons. But
Yes.
he also says he should lead the witness first. Am I correct, sir?
No, just advance the reasons,
The
my Lord,
reasons.
and if they want to respond.
Oh, I see. Fine. Okay.
Yes.
Okay. I'm sorry about it.
There's a court, please, my Lord.
Yeah. Okay. Can we start then?
Yes, we are on page 1. We mentioned, my Lord, that Mr. Mngomezelo has indicated that he'll object to the evidence of this witness, and we then give background of the propositions that Mr. Mngomezelo put to the witness, and under introduction we quote the record. This record, my Lord, are the proceedings that occurred on the 28th of August 2024. He put the following proposition to Lieutenant Colonel Mangena, Mr. Mngomezelo. All right, let me put it, and my Lord, I must apologize, there are a lot of words in these heads that are just fresh from the printing press. We just prepared them shortly before we started this morning. Mr. Mngomezelo, all right, let me put this version to you. According to those witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi on her leg. The other shot is the one that Longwe Thwala shot himself on the leg while they were struggling for the gun. The third one is the one that shot Senzo Meiwa. Says, but I'm not mentioning, then on page 3, I'm not mentioning them according to the sequence of how they happened. I mean, all these 3 shots, they caused injury to Zandi. The one was stuck in the angle of Longwe Thwala, and the other one is the one that shot Senzo dead. Then Mr. Mangena, he says, you know, he doesn't know of any injuries to Longwe. Then Mr. Ngomezulu. Longwe, after that incident, that wound became septic, and he went to a doctor, the late Dr. Mbatsani, who referred Longwe Thwala to Dr. Modise at Rand Hospital, where a bullet was taken from Longwe's foot. Then we go straight to paragraph 2, my lord. We mentioned that these allegations are so serious as they go to the heart of what is at issue in this case, and they ought to be investigated. And my lord, if AVL or auto vehicle location records can assist the court in the determination of these issues, that it is in the interest of justice that this evidence be allowed. In paragraph 3, you mentioned that automatic vehicle location is a computer-based vehicle tracking system used to monitor the movement of vehicles. It helps to determine and transmit the geographic location of a vehicle in real time. And as we submitted when we dealt with the evidence of Mr. Dikre, said it's, you know, eye in the sky. Mr. Mgumezulu says this is here evidence. It's not here hearsay evidence, it's a real evidence. It's digital evidence, and it qualifies as real evidence. In paragraph 3.1, we mentioned that the AVL records will therefore show the movement of the Polo, including whether it drove to any medical facility, in light of the proposition that was put to Colonel Mangena that Mr. Longwe Thwala shot himself in the foot. And 3.2, in contrast to what Mr. Mgomezulu submitted, we make the point, my lord, that AVL records are independent, objective evidence, and as it were a silent witness, and we draw parallel with cell phone records, my lord. They're just like cell phone records or bank records. One can surely not argue that cell phone records or bank records are hearsay evidence if there is a witness who comes and give testimony on those records. In paragraph 3.3, we briefly mentioned that a tracking device is installed in a particular vehicle which provides vehicle location information, and a witness from a tracking company, and the witness is now here, would come and testify that in this case she retrieved the information from the system and testify about the period to which it relates. In paragraph 3.4, we mentioned, my lord, that Mrs. Zandi Kumalo, Mr. Tumelo Madala, Mr. Mtokozisi Thwala, and to a certain extent Mr. Kai Ngashe, inter alia testified about the presence of a red Polo on the premises on the evening of the incident, and that Mr. Longwe Thwala was the driver. This, in our submission, my lord, renders the evidence reliable and validate the information that the AVL records will provide. In paragraph 4, we deal briefly with relevance, that the starting point is that all relevant evidence is admissible. We refer to section 210 of the Criminal Procedure Act 51 of 1977, which provides as follows, and we quote, "No evidence as to any fact, matter or thing shall be admissible, which is irrelevant or immaterial and which cannot serve to prove or disprove any point or fact at issue in criminal proceedings." And we then quote the esteemed author de Troy, where he states the following: "Relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which evidence is offered." And the learned author says relevance is essentially a question of fact. And we refer to the commentary on the Criminal Procedure Act. It's pages 24 to 22B, 24 to 22 to 22. And we mentioned, my lord, that at times a distinction is often drawn between facta probanda, that is now the facts in dispute, and facta probandum, that is the facts that are used to determine those facts that are in dispute. In this instance, my lord, a proposition has been made that Mr. Longwe Thwala shot himself in the process of shooting the deceased, and the AVL records would assist the court in determining whether that proposition that was put forward is likely to be true or not. Then interest of justice, we will not deal much with that, my lord. We submit that it is in the interest of justice to allow this evidence to determine the movement of Longwe in light of the version that was put to Colonel Mangena. And we refer to the local classicals of R versus Hepworth. We give the quotation there that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice is done. And we also refer to this case of State versus Sheikh. The reference is given there. We just want to quote what was said there, that the applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsections 35(3)(a) to (o) of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. We also refer to the multi-choice case, and we give the reference there. We just want to place on record what the SCA held by the current JP of this division, but then the SCA judge, Judge Mlambo, he held as follows: our constitutional code has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And they then quoted the case of Zukuza. We give the quotation there, where in the court held that a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And finally, we refer to the case of State versus Dlamini, Dal and others. We give the quotation there, where the then Constitutional Court Judge Krichler held as follows, that the phrase interest of justice is a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my Lord, that the state should be allowed to examine this witness on the AVL records.
Can interpret.
That's a good pieces. Lapha ke kukhona ke okufakwe ummeli kuba ungumezulu ethi yena ngeke athandisise ukuthi lo fakazi eze azoletha ubufakazi enkantolo bese kufundwa ke okwakhulunyiwe ngomhla ka-28 August 2024 and lapho ke ungumezulu ekhuluma no-Colonel Mangena okwavela lapho ukuthi kwadutshulwa kathathu khona inhlamvu yokuqala yashaya uZandi enye inhlamvu kuthiwa ke uLongwe Thwala wazidubula yena wazilimaza ngesikhathi ke belwela isibhamu esithathu inhlamvu kwathiwa yile yadubula uSenzomiwe kodwa ke kuthiwa ke njengoba kubekiwe kokuthathu lokho akubekwanga ngendlela okulandelana ngayo kuthiwa ke uLongwe kwahamba ya kuDr. Mbatsane lapho wamdlulisela ukuthi bayomkhipha inhlamvu. Manje lelo bufakazi lobu busiza ukuthi ke kwazi ukuthi imoto yahamba ngoba ngavela ukuthize nokuthi imoto yadlula yakodokotela kuzobonakala ukuthi ngempela imoto yayishayelwa ubani. Manje kuba ngumezulu ukuthi lo bufakazi obulethwa la enkantolo abone ubufakazi obuqotho, ubufakazi nje obuzwa abantu kuthiwa hearsay evidence isilungu, and then sheshisi yena uthi cha ubufakazi ngempela lo ngoba kuzokhombisa ukuthi imoto yahamba yaya endaweni la uthola ukunemtholampilo khona, futhi ke uthi lokho kuqhathanisa futhi nama-cellphone record. Manje ke impikiswano ke lapho ukuthi kuyalethwa indlufakazi la enkantolo kusho ukuthi yebo akakhulume kusisi lokho emlethela enkantolo sokuzobeke nempikiswano ngalokho.
Yeah, the defense, do you need more time? If you want to prepare your own arguments on paper, all the better. Because I don't want anybody to say he never had an opportunity to respond to this document. So if you want us to adjourn until tomorrow, I don't have a problem. And then you prepare also a substantive argument.
My Lord, speaking on behalf of Mr. Mngube, I'm ready to respond now from the bar.
Mr. Mngumezulu?
I'm ready to respond from the bar.
Mr. Msipili?
I will also respond from the bar, my Lord.
Mr. Ngumalo?
I will also respond from the bar, thank you.
Ms. Mshorolo?
I have no submissions.
You have?
No submissions.
Ah, you must have. You can't be in the air. It's either you are in heaven or on the ground.
My Lord, if we were to look at the procedure, the way things are happening, the application has been brought by the state, then that will mean that the defense will also have to be given time to prepare their
That's it. I want to give you the time if you so want it. But your four colleagues here, they say they are ready. If you say you want extra time, it is your client's constitutional right to insist on that.
As the court pleases, my lord. If that can be allowed, I'll ask that opportunity, my lord.
How long do you need? A day? Week?
I can prepare my heads tonight and submit them tomorrow.
Ma'am, where do you live? I'm sorry to ask you that. Don't give me the street and the address. Are you living in England or where?
My lord, Krugersdorp.
Oh, you're my neighbor here.
Yes, my lord.
Okay, are you available tomorrow?
Yes, I am, my lord.
Yeah, you heard the argument.
I did.
Yeah, the defense has a right to respond because according to Mr. Mgomezulu, he says they are ambushed.
Yes, my lord.
Hulle was nie gereed.
I do understand, my lord.
Okay. Yeah, because of that existence, this court will adjourn until tomorrow.
My lord, if the case is adjourned until tomorrow, my lord, can I ask that I be given opportunity to consult on this document with accused number 5 so that he cannot be taken immediately?
Fine, no problem. Because normally number 5 goes to where he stays at about 4 o'clock. Is that not so?
Yes, my lord.
Where's General Brigadier Ginin? Have you sorted out that thing amongst yourselves?
I have explained.
Amongst yourselves.
Indeed, I've explained that to my colleagues, and I think to afford him some privacy, my lord, if we can address this issue off record, off record, my lord, in light of the fact that the proceedings are carried live. It's an issue that we request that it be addressed in chambers.
You're excused, ma'am. Proceed tomorrow at 10 o'clock. Okay?
Thank you, my lord.
Sorry about today. Sorry, Mr. Balui, you say the record of the, you call it what, an AVL machine?
Yes, that is exhibit that we have placed before.
Yeah, I'm saying you have given it to the councils, all of them?
Yes, on Monday.
All of them, okay, so fine. So you want us to address this issue in private? Why should it be private?
Well, I think someone's studies are, a private matter.
No, I don't like privacy because people talk a lot. They will say we are doing this and this and this in private. Mr. Brigadier Gininda, I think, can tell us what he thinks about, and then even the councillors can come in also. Yes. And if they think it's not necessary for him to be excused from his studies, that's it.
Well, I've communicated to my colleagues this morning what his preference and request is, my lord, because the court wanted to know whether...
Where is he? Let him come and say it here.
Okay.
I think it should be that way. Okay.
Okay.
Please, is he around?
Yeah, he can be made of... I think if we adjourn for a few minutes,
fine.
he can be here.